Well, good afternoon, everybody. This is Brian Manier with Keystone Financial Group. Hope you guys are all having a great week. Welcome to our monthly webinar. Today we have a really important and a subject matter that I would say a lot of people, especially as they get into their retirement years, have some concerns and want some information about, and that's going to be specifically talking about long-term care. We have Dirk Winkler on with us. He's going to be talking a little bit about Medicaid and long-term care and how those two work together. And so we're very grateful that Dirk took some time today to talk about this important subject. So with that, I'm going to go ahead and turn this over to Dirk. Dirk, welcome. Thanks so much for coming in today and talking about this subject.
Well, thank you, Brian. I appreciate it. Yes. Today, I would like to take some of the mystery out of long-term care planning. One of the most important questions that we receive in our practice is, what do I need to do in order to afford long-term care should my spouse or myself need assistance? So what I'm trying to give you today is going to be a 30,000-foot overview. I'm only licensed in the state of Ohio, so the circumstances and facts that I may be presenting and the law is going to be applicable to the state of Ohio, but generally the Medicaid and long-term care planning is a joint state and federal program, so please refer to your state, but a lot of the principles will be the same. Let me give you an overview of who I am and what I do. My name is Dirk Winkler. I'm the founding attorney of Winkler Legal. Been in practice since 2004. Our law firm is a firm dedicated to focusing on issues facing senior citizens and their families. Practice areas that we focus on is long-term care planning, the subject we're going to be discussing today. We also provide estate planning services, probate and guardianship work, and then also special needs planning for individuals with loved ones with disabilities or special needs. Well, what exactly is long-term care planning? Long-term care planning refers to the services and medical support necessary to meet personal and health care needs as we age. Now, this is very important because in our line of work, we call it the age continuum. And oftentimes we have to talk to families and elders about how do they want to manage their care as they age. And it is, in fact, one of those concerns that helps us answer questions and then provide a family and the elder a progression of how we are going to provide care and necessary medical treatment as a person ages. Now, there's 3 stages to long-term care. Independent living is when individuals live in their home without assistance or supervision. The next step in the aging process is what we call just assisted living. Assisted living is where an individual can live independently, but requires some assistance with activities of daily living, and it can occur at a home or in an assisted living facility. And then there's skilled nursing care. Now, skilled nursing care are individuals who require round-the-clock care, medical and rehabilitative services, and assistance with activities of daily living. Most skilled nursing care, in fact, all skilled nursing care, occurs in a nursing care facility. It is at this point in time where the individual, the elder, for whatever reason, is unable medically to live independent or in what we would consider a step-down medical facility. Who needs long-term care? Well, it's estimated by 2060, nearly 1/4 of Americans will be age 65 and older. With that trend increasing every single year, there's 10,000 Americans are turning 65 every day. So nationally and on the state level, we're facing increasing demand for these services, which just requires additional planning and a lot more thought into the aging process and how to pay for this care. Now, who needs long-term care? According to the United States Department of Health and Human Services, at least 52% of Americans 65 and older will need long-term care services in their lifetime. So this would be assisted living services and full nursing care services. In the state of Ohio, the annual cost of long-term skilled nursing care for a semi-private room is $85,000, over $85,000. Nationally, it's approaching $90,000. In fact, in the state of New York and other higher states, it's approaching $120,000. How do we pay for long-term skilled nursing care? Now, this is the $64,000 question that everyone is wrestling with right now. These are the four primary ways to pay for your long-term nursing care. Self-pay, and it requires spending down your hard-earned assets to pay for care. So you've amassed wealth, you've amassed assets, you've skimped and saved. Well, this is, unfortunately, if you self-pay, this is one of the methods that you can pay for services, but you're going to be spending down your assets. And if you're married or have dependents living at home, it's not providing the financial security going forward. Now, long-term care insurance is a viable option. We recommend every single one of our clients at least look into long-term care insurance if they don't have it, even if they're in their 60s or 70s. It's a good way to hedge against the costs. But if you look at the actual numbers, fewer than 8% of Americans purchase long-term care health or long-term care insurance. And a lot of that is attributable to cost, and a lot of it is just attributable to just a misunderstanding as to the role of long-term care insurance plays. Medicaid. Medicaid is available in all states. It's a federal-state joint program. But Medicaid is the largest payer of nursing home care and costs. However, in order to qualify for Medicaid, you must meet state-specific income and asset requirements. And then there's other options. VA benefits are available to veterans and their spouses. Aid and attendance can be a benefit that can help pay for long-term care costs. And then the other option would be relying on friends and family, which is not uncommon. Now, who pays for care? This is just putting into a pie graph where the payments are made for long-term care. Medicaid by far is the largest payer of long-term care in the United States. Out-of-pocket is about 22%, other private funds 11.6%, and then other public funds that may be available through state departments of mental health and and disabilities. Now, I've already stated Medicaid is the largest largest payer of long-term care in the United States. But how do we qualify for Medicaid? Now, remember, I'm keeping this at a 30,000-foot level. What I want to at least be able to impart to listeners today is you just have a basic understanding of some of the factors and criteria used in determining whether you would be able to qualify for Medicaid. But however, there are two primary factors that are considered when qualifying for Medicaid. It's going to be the applicant's income, and it's also going to be the resources or assets. Now, when it comes to Medicaid qualification, there's two distinct groups of applicants. There's single applicants, either they're widowed or they don't have a spouse, and then there's married. I will briefly just break down some of just the highlights of what applies under each circumstance. If you're single and your monthly income exceeds $6,620, and this is in the state of Ohio, you will not be eligible for Medicaid. Also, if out of that $6,620, the applicant will receive $50 stipend and cost of Medicare supplemental premium. So what I'm looking at first is Medicaid will determine whether your income is too high to even qualify. Most income includable in this group would be Social Security, pensions, and then there's certain annuity payments. This would be regular reoccurring income, whether it's taxable or non-taxable. Once you receive your $50 stipend and Medicaid supplemental premium carve-out of your income, the entirety of the remainder of your income goes to your cost of care. So if you're single, there's very few caveats to protect your income. The only other way it would be is if you're single and you have a dependent in home. We would be able to peel off some of the income. But if this is a straight single individual, this is going to be the primary income criteria that we would be looking at. Now, the information for the married is the name on the check. And we'll get to resources or assets at a later slide. When you're married, the name on the check is controls. So if you have a spouse, a well spouse that's remaining at home, and you have an applicant that is in a nursing care facility, the name on the check controls. What that means is the applicant's income is going to be the only income that's going to be counted for purposes of Medicaid eligibility. That means that the spouse, the well spouse, the spouse remaining outside or not institutionalized, will be able to keep 100% of his or her money that comes in their name. Now, there is an exception. If the well spouse's income is less than $2,057.50, we may be able to, the spouse may be able to receive a portion of the applicant's income up to a total of $3,161. Now, these are state of Ohio numbers. Every state has different numbers. But what we're looking at is if the well spouse, the spouse that is not receiving nursing care, has income that's less than the 2,057 threshold, we would be able to peel off additional income from the applicant in order to support that well spouse. Now, in addition to being able to carve out the additional income, the well spouse would also be able to peel off shelter care costs. In Ohio, it's the maximum of $617.25, and a utility allowance of $544. However, if you take the shelter cost and the utility allowance and add it to the full income of $3,161, you're a little over $4,000 that is available to the well spouse. Assets. There are exempt assets and non-exempt assets. The primary residence, whether you're single or married, can be protected during the applicant's stay in a nursing home facility. The reason I put a state recovery there is if you are single, we can protect the home during your lifetime in receiving long-term care. However, just be mindful that if that primary residence, if the resident remains in the applicant's name, the state, in this instance, the state of Ohio, would have an estate recovery action to be able to, against probate assets, and usually the residence is the primary asset, to seek recovery for Medicaid expenditures on the applicant's care during their lifetime. Another exempt asset is you're given one automobile. You're also, your personal and household belongings are not factored into the Medicaid equation. If you have an irrevocable funeral contract, that is also an exempt asset, which means you can spend money on a funeral contract and the cost of that funeral contract will not be considered an asset or a resource for qualifying for Medicaid. And then also if you transfer assets 5 years before applying for Medicaid services. Now this is a very important concept. A lot of people are familiar with the 5-year look back, and that's about all they know about about Medicaid planning. But what ends up happening is, in a nutshell, when you apply for Medicaid services, there's going to be what we call a snapshot date, the date you're entering and receiving care and your application is submitted. Medicaid's going to look back 5 years and determine what assets you owned over those last 5 years and whether you have sold or transferred those assets for less than fair market consideration. what the state of Ohio, for instance, is trying to determine is did somebody just simply give their assets away knowing that they're likely to go into a nursing home and just give them away as gifts during that 5-year look back. If that's the case, the state of Ohio is going to assess the value of those assets that were given away for less than fair market value, those assets that were gifted, as part of your qualifying for care under Medicaid. Now, there's non-exempt assets. Non-exempt assets are assets that single and married individuals own that are not considered, that will be factored in regardless. And those would be checking and savings accounts, stocks, bonds, mutual funds, land contracts, promissory notes, IRAs, and so forth. These are all assets that on the date that you're applying for Medicaid, if you own these assets, the Medicaid office will consider the total value of those assets when factoring in a qualification, whether you qualify for Medicaid or not. Now, this is, before we start drilling down here, conceptually, just look at it this way. Medicaid is trying to determine what's the total amount of resources an applicant has. So if we have a single individual who owns a house, an automobile, and has an irrevocable funeral contract, all three of those assets will not be counted immediately for eligibility. However, if the same single individual had an IRA worth $300,000, had a whole life policy with $100,000 in cash, and had a savings and checking account with a couple $100,000 in it, all of those assets will be considered a resource to determine whether this individual will qualify for Medicaid assistance. Now, one additional piece is that when the state of Ohio and Medicaid is determining eligibility, they're trying to arrive at a certain asset amount that they will deem to be a resource, which means in addition to income. Now, under the state of Ohio and most states, the applicant themselves is allowed to retain $2,000 in their own name. With that being said, what do we do with remaining resources or assets in the individual or applicant's name? A single applicant, all the assets, if they're in their individual name, then is going to be counted. Now, if you're married, it complicates the rules slightly, and this is just regarding assets. All assets, whether it's in the well spouse's name or the applicant's name, is considered a joint asset. What that means, though, is that the totality of all the non-exempt assets, both spouses, is going to be considered available for the applicant, the applicant's care from a Medicaid standpoint. Now, if you're married, the well spouse will receive the first $25,284 out of the assets. And this is just a means to provide the well spouse some financial security, even though $25,000 is not a significant amount of money. However, if there are assets, joint assets, worth more than $252,840, they will be divided equally. So under this slide, the well spouse receives the first $25,284. However, the well spouse may only retain a total of $126,420. What happens is any assets above the initial $25,284 will be split equally among the spouses, up to a total of $252,840. Any assets above the $252,000 limit is going to be considered a resource for the applicant's care. The marital home. Now, in the single individual circumstance, I previously explained that there's a state recovery mechanism if the home was in the single individual's name at the time. If you're married, the rules are slightly different. The well spouse, so long as the well spouse is living in the home, 100% of that home, up to $585,000 in equity, can be protected. And there will not be a need for a state recovery, or there will not be a fear of a state recovery because the well spouse is still residing there. Additionally, if you have a qualified dependent living in the home, then the home will also be protected. But remember, the equity in the home can only be protected up to $585,000 in equity. Again, a state recovery, although the marital home is exempt, the state of Ohio may pursue a state recovery. That's one of the overlooked issues when we do long-term care planning. Is a lot of individuals say, well, I'll just give this, I will just keep the home, and it can be exempt while I'm not here for a single individual, but as soon as I pass, then the state will come after it. If you're married, there's a little more protection because the well spouse can do what he or she wants with the home, irrespective of whether the applicant is receiving nursing care and is qualified under Medicaid. The major point here is by planning ahead, using irrevocable trust, you can protect assets and qualify for Medicaid assistance much sooner. There are two types of protection planning. There's pre-planning and crisis planning. From a lawyer's standpoint, pre-planning is the best option because we have more arrows in our quiver in order to protect assets. We can protect, as long as you plan at least 5 years before an anticipated long-term care event, that will allow us to protect most of your assets. And then when a healthcare or catastrophic event occurs requiring long-term care, we have protected your assets and reduced the penalty period to get you qualified sooner for Medicaid assistance. The second type of planning is crisis planning, and unfortunately, this is some of the most common planning. This is usually we get a call from a family member, or we have a loved one calling our office saying, "Look, my dad's just been released from the hospital, and he's going to a nursing home facility for rehabilitation, but it's likely the doctor said that he's not going to be able to return home. What can we do?" So we have the catastrophic event, we get the phone call, and most families and others are, okay, how are we going to pay for this? Now, with crisis planning, there are things we can do to protect half of the assets and also get the individual qualified for Medicaid. However, the individual is going to have to spend down a certain amount of assets. As an overview, Medicaid will determine what are the available assets and available resources that the applicant has, and if married, the joint assets of the parties. And they will determine that value in addition to income. The income, we have little protection over. Income is going to go to the care of the applicant unless the applicant is married and we're able to peel off some of the income to help support the well spouse with his or her living expenses. The one way to look at it is the state of Ohio, for instance, will simply arrive at an asset amount. Let's just say there's $300,000 in assets available, and we have an income, applicant's income of approximately $2,500 a month going towards care. And if the monthly expense, private pay expense for the nursing home is $10,000, that $300,000 is going to be spent down at $7,500 a clip each month until it's down to $2,000. That's how Medicaid will look at it as far as qualifying and getting you qualified for Medicaid. Now, the state of Ohio is not going to demand that any gifts or any transfer of assets during the 5-year look-back period be returned. They're just going to simply say that you are going to have to pay for care. And if you have gifted assets to a loved one or a grandchild, and that individual has already spent those assets, it puts people in a difficult position. For one reason that we find most helpful in Medicaid planning is using irrevocable trusts, which we can then place assets in the trust and secure those assets for your use until you need long-term nursing care, at which time those assets would remain in the trust. But if we would need to access those assets, we could break the trust. This concludes my presentation.
Okay. Dirk, thank you so much for being a part of this. Appreciate you having us aboard. If you have any questions about the information that Dirk talked about, his information is there on the screen, whether you want to email him or call him. Or if you have any questions that you want to talk to your advisor about, feel free to call Rose at our office. Our direct line here is 614-300-9501. That concludes our time. Dirk, thank you again so much, and look forward to having you back on another time. And we also look forward to having you guys next month. Take care and have a good rest of the week.